All right. I would love to welcome everybody to the Demystifying Intellectual Property webinar. This is done in collaboration with the Vermont Small Business Law Center and the Financial Futures programs over at CVOEO. Just a bit of housekeeping. I will keep this recording on throughout so that folks that were unable to join us today can view it after the fact. As Simeon mentioned, please mute yourself when you are not speaking and make sure that your name is reflected in the Zoom window, which it looks like everybody's is. Please enter your questions into the chat. Simeon and I will be monitoring these and making sure that Professor Goodenough gets to them. And after the workshop, you will receive an email with this information along with other links and resources and contact information for both our program as well as Vermont Law and Graduate School. So without further ado, I will pass it off to Simeon Geiger.
Good morning again, everybody. So glad you could join us today. I'm Simeon Geigel with the CVOEO Micro Business Development Program. Just a brief mention about our program. We work with low to moderate income Vermonters that would like to start or expand a business. So we provide free business counseling services to those who qualify. So obviously there's no cost for that. And if you'd like to learn if you qualify, you can just simply email us and we'll just ask you a couple of questions. And then if that all checks out, we'll move towards finding a time to meet. We have 3 counselors at our location, myself, John Gergley, and Pacific Sangayuva. Next slide, please. I did mention that CVOEO, I think I mentioned that CVOEO is a statewide program. If I didn't, it is. And so there's a total of 5 micro businesses that cover the state that can help you with starting or expanding your business. Each micro business covers a different set of counties. And so you can see from this list which micro businesses cover which county. We have Brock covering Bennington, Rutland, Capstone Community Action, which covers Washington, Lamoille, East and West Orange counties. CVOEO, my program, which covers Addison, Chittenden, Franklin, and Grand Isle. NECA covers Northeast Kingdom, consisting of Caledonia and Essex Orleans. And finally, SEVCA down in Windham and Windsor. And we do need to update that contact for SEVCA. So if you're down in SEVCA, Windham, Windsor counties, and you want to know the contact person down there, please just feel free to put it into chat and I will provide you with that. Finally, you can see our list of counselors at mbdp.org, and you can reach out directly through our statewide website as well. Next slide, please.
Sorry about that, Simeon. It looks like my slides are a bit frozen.
Oh,
Let me
okay.
try.
Yeah.
Here we go.
Technology, it's great when it works.
Right.
Great. So I always like to make people aware that there are lots of helpful business support services in our area. In Burlington, there's also the Burlington's Business and Workforce Development Program. They focus on people who want to start or expand a business in Burlington. There's the Center for Women in Enterprise, Mercy Connections, Women's Small Business Program, the Vermont Small Business Development Center, SBDC, the Small Business Administration, that's a federal program, and finally, Champlain Valley SCORE. All of these programs have great resources and are very helpful, and I encourage everybody to tap into the strengths of the folks that work at these programs to help you with your business. Next slide. Finally, we just want to mention a thank you and appreciation for our partners that are collaborating with us on this class. That includes People's Trust up in the St. Albans area. They offer a variety of commercial and business banking products and services, as well as consulting services to help their clients succeed. Jay Cummings is the contact person there, a really great guy, very, very helpful, and very networked with the business community. So don't hesitate to reach out to Jay if you feel like that would be something that would help you and your business. Next slide. And finally, we are collaborating with the regional development corporations. Vermont's regional development corporations are the state's primary partners in implementing economic and development in the regions. And so there's 4 regional corporations listed here, and these cover different counties in the state. We've got one for Greater Burlington, Greater and Burlington Industrial Corporation, GBIC, one covering Lake Champlain Islands, up in the islands, Franklin County, of course, and then Addison County Economic Development Corporation. So phenomenal business resources. I encourage you to reach out to them for networking and to connect with their services as well. Next slide, please. Finally, we'd like to get started and get to things. And so I'd like to introduce Oliver Goodenough, research professor of law with the Vermont Law School. We are so thrilled to have him back today to talk about intellectual property. And it's something I'm really personally interested in learning more about. So Oliver, thank you so much for providing your time and energy and knowledge on this subject. I'm really looking forward to learning more.
Well, thank you so much, Simeon. That's great to be with you today. Great to see so many folks interested in intellectual property. It's one of the subjects I teach at the law school. And I should mention, by the way, if there are questions, I think it was covered, but if there are questions, pop them in the chat, and they'll be called to my attention. I don't mind interrupting, and if it's something that breaks the flow too much, I'll suggest just hold on to it until later. But feel free to pop them in so we don't get too behind on questions. The agenda today, we're going to think a bit about intellectual property in terms of what I call the big four. There are basically four major topics: copyright, trademark, patent, and trade secret. And we're going to, as we look at those, we're also going to take it through the lens of what I sometimes call offense and defense, which is where do we need to actually be asserting our intellectual property, and where do we need to be concerned about making sure we don't infringe on other people's intellectual property? Those are sort of as I sometimes call offense and defense questions that businesses have. And the starting point for this is that I'm aiming to give you all an introduction to intellectual property. If you have specific questions that you'd like more education on, I should mention that the Vermont Law and Graduate School's Small Business Legal Center offers individualized educational consultations. We can't give you direct advice, but we can hopefully give you further background on things. And we can also sometimes link people up to legal services, up to 10 hours of free legal services provided by a partnership with the Vermont Bar Association, whose members will be willing to accept our subsidized rate in order to give up to 10 hours of consultation. So again, if there are questions about that, come on board with us. I think there's more information on that at the end of the talk. But the copyright, the trademark, patent, and trade secret, these are the principal things we call intellectual property. What is intellectual property? These are a set of rights in intangible things, in copyright, in creativity, in trademark, a trademark is a designation of the origin of goods and services. Patent, how you do things, inventions. Trade secret, information that we've got that we want to try and keep secret from our competitors. And each of these is a subdivision of the big label of intellectual property. Many businesses, when they're getting going, don't necessarily consider these things. They don't consider them, about what asset could be created from these kinds of rights, and B, also, how do we avoid infringing on other people, the defense side that I mentioned. Also, people all tend to sometimes confuse these different pieces. It's a little bit like someone learning about sports for the first time and confusing, how in baseball, how do I score a touchdown? In basketball, how do I score a run? That's just the wrong questions. They're related. It's like the sports. They're related. They're all sports, but they have different rules, different applications. And what I'm hoping we can do by the end of the day is to get people at least a bit familiar with what it is the domain of each of these different topics, and what are the core generalized rules on it. Again, if folks want further information, we've got an opportunity for doing that as well. Next slide, please. So again, setting the context, we have the big four: copyright, etc., offense and defense, adding value to your business, and avoiding problems with infringement. And one of the key elements for folks who are going to be involved in a business where there's intellectual property involved, I sometimes use the basket idea. If you're going to be selling something that has intellectual property in it, for instance, if one was making a TV show, in order to sell the TV show to anybody else, i.e. through a distributor or something like that, there has to be in the basket of rights enough rights to allow that to go forward. So part of the role of the business people in television is to collect rights from the author of the script, from the director, from all the actors, from the cinematographer. All people involved need to put their copyright rights, as it were, into the basket and then sell it back out again. But again, only to the extent that the rights are already in the basket is there the ability to sell them back out. I hope that's a useful idea. In addition, on the overview, what happens if folks make a mistake and infringe on somebody else's, or quite frankly, if someone infringes on yours? What is available? And there are two principal ways in which the law can be applied. One is through injunction. An injunction is that court order that says, don't do this, typically. Sometimes it's an affirmative injunction that says, do this, but mostly it's a cease and desist order. Stop doing this. And what that can be quite damaging if there's a business going forward that relies on some intellectual property, but it hasn't been properly arranged for, cleared, as we sometimes say. Then the owner of that intellectual property can often come in and say, stop. And that stop means stop the business until this is fixed, which is a very damaging thing for anybody in business, as you can imagine. If people have to stop their business, even for a few weeks while they figure something out, that's extremely damaging. So it's one of the reasons why paying some attention early on is a good idea. And in addition to the injunction, the other basic remedy is damages. And damages are getting typically money from somebody who has infringed. And the money would be, what have I lost by their infringement? What would a normal license have been that I didn't get? Various measures of damages around having infringed intellectual property. Any questions on that sort of basic introductory level? Okay, moving forward. Next slide, please. So we're going to take each of those big four in turn here at the moment. And one of the things I want to point out to you and often is that there are outside resources on this. The U.S. Copyright Office at the copyright.gov has a whole set of resources that are available. The government resources are sometimes not always as accessible as one would like, but the Copyright Office does a pretty good job of making that work. So first question with respect to any of these intellectual property domains and any of the games, as it were, the sports that we're talking about, is that what is covered? And in the case of copyright, what is covered is original, and here's the quote from the statute, works of authorship fixed in a tangible medium of expression. And a work of authorship is really a kind of a catch-all for creative work. It can be fine arts. It can be drawing and painting. It can be sculpture. It can be music, musical composition. It can be film and television. It can be photos. It can be writings. It can be books or short stories or poems or even technical writing like manuals. Sometimes people don't think they have intellectual property, but if they're offering say an educational service as an online educational service, and it comes with a background material, that background material is likely to be possibly subject to some copyright protection. Even some computer programming can have some copyright protection. Copyright can cover some computer programming. So there's a broad range of things that copyright can cover. And how does that come about? Well, if you've got the right kind of material, there's automatic coverage under the Copyright Act for authors. And authors are individuals who are the creative force, or companies under a doctrine called work for hire. And let me take just a moment on work for hire. Because work for hire needs to be specified in a contract, although sometimes it'll just attach if the person is a regular employee, work of a regular employee, the creative work in the context of their employment may well just be the property of the employer. But even in that context, it's really good idea to have a contract that just says, hey, if you, the employee, write a manual or whatever it is that you're going to do creatively in the context of the company's business, the company owns it. And that's not unfair to ask for employees who are being employed to do that kind of work. So again, and if there is, if it isn't an employment circumstance, but in certain limited contexts of like a composite work or maps, there's a whole list in the copyright law. That can also be a work for hire. The nice thing about a work for hire is that it automatically goes into the company's basket. Basically, the company is now the author, and it gets it into their basket. Even if they're not works for hire, again, the rights can be transferred under an agreement saying, hey, you're giving us the rights in that book. You're giving us the rights in whatever it is. So that's a very important piece to know, is that who is the author and how is the author's rights getting transferred up to the company. Another thing that's often there is the formalities. The formalities are useful, but they're not make or break anymore. 50 years ago, before the most recent copyright, major copyright revisions back in 1976, if you didn't do the formalities correctly, you could lose your copyright. But that's not the case anymore. But you do get extra protection if you do the formalities. So here, for instance, one of the two basic formalities are the notice, which is that C in the circle, the name of the author, and the date of the publication that gives rise to it being available to the public. So with respect to this talk, I should have somewhere on these slides, copyright Oliver Goodenough, 2024. That would be the way to give people notice that it's my creation and I'm claiming copyright in. A further formality is registration. And registration, again, is not a requirement for basic protections, but it is often a requirement before a cause of action can be brought, before enforcement can be requested from a court. So getting that filing in can be important, particularly if there's any litigation seen, but even just as a general matter, it's not a bad idea to do the registration. And here, this is on copyright.gov, has a whole system of ways of registering online, and do-it-yourself is possible here. There are other web services that will act as an interface for you. LegalZoom, some other companies will say, hey, we'll act as your interface. Well, they're just basically an interface on top of the Copyright Office's interface. It can be useful, but people can often do that on their own. And again, just explore that there. What are the rights we get? The rights are long on copyright. They are the life of the author, or the last to die if it's more than one author, plus 70 years. So that can be a long time, particularly if something's written while they're by someone while they're a young person. They get 50 more years of life, and then they get 70 years on top of that. So that would be a total of 120 years of protection. Woohoo! 95 years if it's a work for hire. Basically, if it's corporate work, it's going to be 95 years. Next slide. So what are the rights you get? Okay, I've got a copyright. Now, what are my rights? And the rights are listed in Section 106 of the Copyright Act. And they basically say, I, as a copyright holder, can control the making of copies. So if it's a book, copies. If it's a sound recording, records, or whatever it is. If it's a film or a TV show, and a DVD, whatever. So making new copies. I control their sale, at least the first sale of those copies, and I can control their distribution, which means that even if it's not a new copy, if it's being streamed, if it's like web distribution, if it's being broadcast, if it's being distributed in some way, I can control that as well. I can also control public performance and display of that work, which includes typically broadcasts and web distribution, but also includes just live theater. And if I put it up for display and ask for pay on it, I can the copyright holder can control that as well. So first big thing, copies, their sale and distribution, performances, their sale and performance and display. Third thing that's of importance is derivative works. because derivative works are things like someone takes the Harry Potter stories and creates a new Harry Potter story. Well, that's interesting, but that has to be cleared with the original holder, because the original holder has the right to control who gets to make works that are derivative. What is a derivative work? It's one with enough contact to the prior work to really take the expression, to take the protected elements of that work. Some special rules on music, radio, and streaming. I should just mention that radio is funky in this context, and there's some special rules. Radio has permission to use certain performances of recorded performances, but has to pay for the underlying music. The streaming services have to pay for both. All right, so offense and some use cases. All right. Again, as I mentioned earlier, make sure you get your rights from employees, contractors, whatever it is you're going to be working on. Get an assignment. Well, how do we get the rights? We basically get some kind of document, some kind of contract providing an assignment, and that assignment should say the rights in X, whatever that is, are being transferred to my company. Again, if it's a book or something like that, it won't be necessarily a full assignment, but at least a sufficient license to cover the business that we're planning to do. So on the rule for offense is to do that again, and it's not just explicitly creative businesses that worry about this. As I mentioned, a manual on the use of some object. That could be written by somebody third party. They would have copyright on that unless the copyright was transferred in some kind of license, permission, or assignment. Websites, web designs, etc. One hires a third party web designer. The contract with that web designer should make it clear that the the intellectual property content of that, the copyright, is all transferred to the owner of the website to use as they want going forward. So again, it's that kind of use that we see people having to make. Explicitly creative businesses, clearly in this case, but even not explicitly creative businesses, whenever a creative element is being used, that needs to be considered and make sure the contracts are in place. On defense, some use cases. Clearance. Am I using somebody else's book? Am I using somebody else's material? Am I using a song from somebody else? Clear it. And that clearance can be both specific and for the particular use, or general. Say, hey, and any uses of the following category. Political campaigns sometimes run into this. I believe that Donald Trump's campaign is now getting chased by somebody because they used the copyrighted song of somebody in a rally in a context. So again, one wouldn't think of necessarily as political rallies as being a context for this, but they are. Again, any use that might constitute an infringement. I should mention, by the way, a big exception to some of this, which is the exception of fair use. And fair use is a section of the Copyright Act that allows folks to use without permission for certain kinds of purposes. That's somewhat limited, but it's not endlessly limited. They tend to be things like, if I'm writing a review of a novel, I get to quote from the novel. If I'm doing a review of a movie, I get to show brief video clips of the movie. Again, not enough so that it substitutes for seeing the movie, but enough so that the fair commentary that I'm doing. Classrooms have an exception for brief use of material, or for you running. I could show a movie in my classroom to say, hey, look at this movie for this educational purpose. I can't do it just to entertain my students, but I can do it to do that. So again, there are fair use exceptions which can sometimes apply, and if so, that's great. And there can be some other exceptions. For instance, there's a specific exemption for the performance of music in a religious service. So if a church choir needs to pay for the music when they buy it, but they don't have to pay a royalty for performing it in the church service. Why? Because the copyright says that's okay on other religious services as well. So again, there is a list of specific exemptions. I'm not going to go into them in great depth now, but again, if that's something that comes up in a context that would be specific to your business, keep that in mind and get some legal advice on that. I believe that's my two slides on copyright. Before I leave the subject, questions? Anybody have a question on copyright while we're here? Not seeing anything, or
All right, I've got one that occurred to
sure,
me.
go ahead, fire away.
You mentioned on the previous slide that that the that the owner retains the rights for 70 years to 95 years, and if that person passes, um, do those rights get transferred?
Yes. So it's life plus 70 for individual authors.
Mhm.
And if that individual author passes away, then the copyright becomes an element in that person's estate and would typically be passed in a way of having to do with that estate. If the person who's dying has already made a license, the person taking would take subject to the licenses that the individual made. Because you can't take what you don't have, you can't pass on what you don't have. The copyright would pass. Worked with the estate of some famous authors once upon a time, and the recipients reintroducing the copyright protection after the 70 years had gone, which included new editions, yay, which they licensed and a bunch of things. So there are some things one can do, but essentially the life of the author plus 70 years is a long time, typically, unless you write it like me as an older fella. But even then, if you added 70 years, if I died tomorrow and you add 70 years of my life, that'll get it out to my grandchildren, if not beyond, you know. So the copyright it lasts a long time, and it is a part of the estate.
Great, thank you.
Any other questions? By the way, if it's a work for hire, right, then it belongs to the company, and the company it's an asset of the company. If the company goes bankrupt or something, then those assets would be dealt with in the bankruptcy. In other ways, it's just it's a corporate asset basically, or an LLC asset, a company asset. Oh, all right. Next slide, please.
Quick question on franchise opportunities. If you're sort of preparing a business to franchise,
Yes.
Does copyright come into play with the documents and the SOPs that you're preparing?
Absolutely, because one of the things that often goes with a franchise is a transfer of intellectual property. Typically, trademark, sometimes some trade secret if it involves methods, etc., and often copyright if there is again manuals or even just photos or other pictures, illustrations used in the connection with the activity. So absolutely, and that would be one of these things where again the franchising company typically would make sure it has all the rights into its basket, and then turn around and make limited licensing of that part of what it does as part of the franchise agreement.
Okay, thanks.
Okay, great. Does that answer your question?
Yeah, it does. Yeah.
Okay, great. All right, great. Any other questions? Because I'm happy to be interrupted. Trademark. Whew. So trademark. So if copyright deals with works of authorship fixed in a tangible medium of expression, i.e., those areas of creativity that we've talked about, trademark it deals with designations of origin of goods and services. So it avoids the likelihood of confusion. It's basically the law of branding. How do we set up a brand? How do we police it? How do we get rights in it? The underlying resources on this, at least at the federal level, are available from the U.S. Patent and Trademark Office. Its website is uspto.gov. And patent and trademark are handled by this office. Copyright is handled through the Library of Congress. For historical reasons I won't explain at the moment. Unlike copyright, which is just federal law, trademark is both state and federal. So that Vermont has a trademark registry that one could get a Vermont registered trademark. Folks typically want to go for the national if they can, because the national gives protection throughout the entire United States, and state protection is really much more limited to the state itself. But there's a Vermont trademark registry, and that can be useful. There's New York, California, they all have trademark registries. And sometimes, even if it's an unregistered trademark, state law can be useful. So what is the coverage and purpose? Again, avoiding likelihood of confusion. The core piece of basis of this law was a law called passing off, which we'll get down to a little more below. But passing off basically says I can't pretend to be something else. If I set up a company to sell a carbonated sugar water with some dark food coloring in it, I can't call myself Coca-Cola. Why? Because consumers would be confused, and the company that makes Coca-Cola would be annoyed because they want to protect their goodwill, their trademark, their branding. And the law gives that protection. The core law, the core level is that one cannot, under federal law or under most state laws, pass off one's own work as someone else's, one's own products as somebody else's. And that's the core piece that underlies this. And the question is, would a consumer be likely to be confused by the behavior? So the likelihood of confusion is a touchstone for that. Levels of protectability. What is protectable? There is the level of generic. The beverage I drink most mornings is coffee. I can't trademark coffee because coffee is the thing. So generics typically have very little or no protection at all, because that's the thing. I can't trademark milk. I can't trademark pants. Again, if I'm buying clothing, if I'm buying a pair of pants, that's what I'm buying. So I can't have a brand of that. I can sometimes get protection in what's called a descriptive mark. And descriptive marks are marks that are related to the generic, but have some kind of description involved in it. I don't know if any of you have ever bought something in the grocery store called "Hull of a good cheese." The cheese part can't be trademarked, but "Hull of a good with cheese" might be trademarkable. It's a description, but it's an unusual description, and it can have, particularly if it gets what's called secondary meaning, where it comes to be associated with the public with that kind of cheese. That descriptive mark can sometimes be done. Suggestive is okay. Suggestive is a mark that goes beyond just descriptive and becomes subjective. Arbitrary is good. An arbitrary mark would be something like Apple computer. Apple is a fruit, would be a generic for a food, but it's not a generic. It's an arbitrary mark for a computer. Apple, computers don't grow on trees. So yes, it's a real word, but it is a word that it would be arbitrary in this context. And the best is sometimes fanciful. Fanciful is Exxon. Two X's. Nobody's ever used that word in any particular way until what used to be the Esso company decided it would become the Exxon company instead. And that was a fanciful one, and it is great. By the way, generic drugs sometimes have labels, and they often have lots of X's and Q's in it. Squirk squawks, you have a runny nose, take squirk squawks, and that can be a way to, again, we often see a lot of high value Scrabble letters, if any of you are Scrabble players, in that. So that's the things that could be protected. And then how do we get protection? The first step is to realize that people should be on notice that we're using this as a way to designate our stuff. And that ties into that base level of unfair competition and passing off. And frequently people will put the initials TM after that. That just says, hey, world, this is how I identify my product. The next step up is a federal or state registration, and that gives you that R, that little R circle, or if it's a service, an S in a circle, which didn't automatically convert on my PowerPoint. But registration, there are some qualifications on registration. There's a whole set of things you can't register what other people have registered if it's too close. They won't register things that are generic, descriptive, or descriptive necessarily. Again, there's a set of rules about registration, and it's great if one can select a trademark that is registrable, provided it doesn't infringe on others. Maybe that's okay. For instance, geographic designations may or may not be good. Could I have a Vermont cheese company? I could, and I could call it Vermont Cheese Company, but I'd have only very limited protection until it started to have some secondary meaning. But even without the registration protection, if I could show that people were trying to infringe on my Vermont and passing off, I could still sue, even if it's not registered or even registerable. That's a little complicated, but you see what I'm saying? So registration is great. It gives you an extra layer of protection, but even unregisterable marks can sometimes collect at least a bit of protection through the unfair competition and passing off basic law. Are there questions on that? Okay, next slide, please. So what is the registration process? At the federal level, basically, it's at that uspto.gov. By the way, that uspto.gov has a list of all registered marks, and searching that registry is a very useful starting point when you're trying to figure out what can I use. Again, that would be a defensive step to do that. So find something distinctive enough to register. That's the first piece. Skipping down to the offensive and use, when you're finding a usable mark, it's hard and getting harder. Many of the clever marks are already taken by somebody. You go, well, this is clever. Well, yeah, it was clever. And 5 years ago, when someone thought about it, they thought it was clever too, and registered it. So one of the key elements is don't fall in love with your mark before finding out if it's available. I worked with a business person who said you gotta have a list of at least 10 or 15, and don't fall in love with any of them, and then figure out, is it distinctive enough to register? So do those searches, figure out something that will work, figure out alternatives, because it just can be a problem. Again, do it yourself here can be okay. You can search, you can fill out the registration form. I have filled out the registration form. I'm a lawyer. It's a little confusing. Expert help can be quite useful here. And online can sometimes be helpful too. Again, things like LegalZoom and other services have a user interface which can be more thorough than the USPTO .gov interface, and can be useful to go forward. And remember, by the way, that URL and corporate names should be cleared too. The whole URL registry piece is a different. The web address registry is a different registry. They will take trademark into account, but it is a different registry and needs to be registered, and may or may not be available. That's another thing to check, and also check corporate names. Sometimes corporations, I would have trouble setting up myself as the Coca-Cola Corporation of Vermont in the corporate name registry, because they would want to be having some distinction. The rules in both of those are a little different than the rules in trademark, but they interrelate, and all of those should be kept in mind when a name is being selected for a business. Rights of the holder. What is the rights of the holder? Get an injunction. Stop using something that's confusing, like mine. Damages, if they've done that, if somebody third party's done it, they can have to be paid damages. And there can also be enforcement at the border. Sometimes if something is coming in from overseas where there is a trademark, where the trademark wasn't registered in China and could be used by the Chinese, Vermont coffee could be used by someone in China, but if they try and bring it into the U.S., if I've managed to register it, then that would be I could ask the customs folks to help enforce. Offense and use cases, finding the usable mark, as I say, do the search at the USPTO, do a Google search, do a URL domain name, get the rights to it. Also, yes, get the rights to design. Sometimes people outsource the rights to a logo. Make sure that those rights are all gotten from the logo designing company as it goes forward. And folks who get trademarks have to actually take some affirmative steps to enforce it, or they lose it. If folks just say, "Oh, I got a registration," and then they never try and enforce it against folks who infringe, that can undo the trademark. That can just say, "Hey, you didn't enforce it. Why should the government?" So that's part of ownership, is enforcing. Defensive use cases. Again, be very careful about whatever marks your company is using. There is a fair use rule here that allows sometimes people to say, "Hey, I'm comparing my cola to Coca-Cola. But Coca-Cola, I'm not claiming I'm Coca-Cola, and I'm not claiming Coca-Cola endorses me. I'm making a comparison, and I'm using their name just to identify them in the context of the comparison. If folks are interested in doing that, that's a place where talking to a lawyer is a pretty good idea, just to make sure that folks know the limits of those that kind of fair use. Accidental infringement is sometimes not as handled as harshly as intentional infringement, but again, one doesn't want to be even in accidental infringement. Anytime one is using a designation of origin, the steps I've talked about making sure it's available, registering if that's possible, then those steps need to be gone through so that folks know what they're doing and who they're doing it. That's trademark basics. So trademark, designations of origins for goods and services, copyright, works of authorship, and a tangible medium of expression. Related, not the same thing. One could have both a copyright in a logo and a trademark use of it and registration of that logo, two different rights attached to a similar object. Are there questions before I go forward to Pat? Okay, folks. Thank you for your patience. By the way, I've got a wheelbarrow full of information. I'm just dumping it on you all. Hopefully that's okay. Again, we're happy to follow up as we go forward. Thank you, Chris. I appreciate the thumbs up. All right. If I don't have questions here, then let me go on to the next slide. And here we have patent. Patent, again, is just a different game and worth knowing what it covers and what the rules are in it. Again, resources, the USPTO, which is patent and trademark, has a fair bit of resources there. There are other resources out there on the web if you're interested in following up. What is its coverage and purpose? It covers inventions. Again, patent, trademark, copyright covers sort of artistic creativity, even if it's not terribly artistic, like an instruction manual. Trademark covers goods, designations of origin of goods and services. This covers inventions, clever inventions. And to be in that category of inventions, it must be one of these big four listed elements. It can be a machine, it can be a manufacturer. Those are relatively self-explanatory. Machine is something that goes whir and click and does something. A manufacturer can go whir and click and do something, but it can also just be the end product, a kind of cereal or something like that. It can be a composition of matter. Composition of matter, interesting. This is basically molecules and alloys and things like that. Most drugs come in under this as well as maybe under manufacture, but they come in as a composition of matter because they are a molecule that's being created to do something. Or a method or process, and this is a little different. This is if you have a very clever way of creating creamies. This is the summer of creamy in Vermont. I've enjoyed my creamies. The creamy itself is probably not patentable anymore because it's been out there for a while. But if I have a new kind of machine that swirls it and does whatever it is, that the machine could be patented, but also the method of making a new creamy could be patented if it was a new way of doing something along that line. So it has to fall into one of those four buckets to be under the subject matter of patent. And by the way, an invention can involve more than one, as I've said. It must be novel. These are, in addition to being in the right category, it has three big criteria. First one is novel. It has to be new. We don't give patents to stuff that folks have been doing for a while. It has to be new to be patented. It has to be useful, and most things that people are seeking patents for are probably going to be useful, but they have to. We have to be specific about its use. Sometimes people get a new molecule and they go, "Whoa, it's a cool new molecule." Well, what does it do? I don't know. I haven't tried it out yet. Well, you can't patent it until you can tell me what it actually does. And finally, it has to be non-obvious, which is related to new. It has to be something that the person who is reasonably skilled in the art, which is the way that they say it, which means somebody who knows about this area of technology, wouldn't just go, "Oh yeah, that's how I'd solve that problem." It has to be have an inventive step to it that would take a little thought and effort to figure out how that was actually going to work. So again, the three big criteria are novel, useful, and non-obvious. By the way, on the novel piece, there's a caution on self-revelation. because it becomes no longer novel if it's been out and published, if it's or in use. Once it's been published or in use, it's not novel. So folks should try and get a patent protection before they publish it, before they put it into use, all of that kind of thing. There is an exception that gives a year's grace period for folks who are the inventors who use it or publish it or whatever. Again, not a great thing to have to rely on, but it's there if one wants to. Okay, so anyway, remember that one of the tricks with patent is to get right at it. So that either do the filing before there's been any publication or public use, or within a year at the latest. Talking to a lawyer on this one, by the way, is really useful. Patent lawyers are patent is complicated. A patent lawyer is something that one needs to probably get a hold of if one's going to do this. I'm aware of some people who do their own patenting. Cool, but it's not for everybody. By the way, I should mention that on the coverage, you cannot patent a law of nature or natural substances. One cannot patent vitamin C. Vitamin C occurs in nature, not patentable. One could patent a method for synthesizing vitamin C from other ingredients. So people who make synthetic vitamin C to put into vitamin pills could potentially get the method process for doing that. But laws of nature also, E equals mc squared. Yeah, can't patent it. It's something that's just out there in nature. Also, sometimes mathematical formulas can't be patented. What can be patented is a way to put that to some use. Ooh, what happens in the patent process when you're developing the process in a public place, such as the? What was the rest of that question? Such as the generator space in Burlington. Okay, cool. 2 or 3 things. One. Oh, did I? Yeah, all right. Now I want to show video. Bang, there we go. Okay. One, anything that's going to be patentable, don't let it out into the general space. Don't show people. If you're going to show people in a subject to an NDA if you can. An NDA provides a zone of privacy that says, hey, this isn't public. I'm trying this out with people in an NDA. If it's already out, don't talk to somebody about filing within a year, because that would be the hopefully available grace period. But yes, be careful with that. Again, don't keep it in a locked drawer. Again, just don't let it out. The generator space should have mutual NDAs back and forward that would say, hey, anything that's proprietary being developed in our space belongs to the people, and we'll keep it quiet. That would negate, or at least go a long way to negating the notion that it had been made available to the public. So it's possible, but it requires a little attention. I would actually, in fact, if I was going into a generator space, might talk to the management there and say, hey, what do we do about the privacy required for patent? They may have thought about it in a way that would be useful. Does that provide enough answer? Again, I don't mean to make you paranoid, but yeah, it's worth paying some attention to if it's going to be patentable and it's being done in a public space. Again, I wouldn't have a public demonstration. I wouldn't say, hey, everybody come on and say, hey, I'm part of the generator space. Let me show you my cool new work. Well, I wouldn't do that if it's going to be patentable. Okay. So next slide. Oh, so no, sorry, back. I'm just talking about the process. Process is an application. It's quite complex and involved. Again, here's where someplace a patent attorney earns their money if they're good. It takes some time. It takes time to construct. So if one's up against it, don't take don't wait to the 11th month of that 12-month period to say, oh, maybe I'll get a patent. It takes some time to get it put together. It also takes a lot of time to review. Typically, the review in the patent office can be months, if not years, in time. There are stages that are possible. There's what's called a preliminary application, which can buy some time. It's still quite involved, but it can buy a bit of time, buys another year, basically, on top of the year grace period that might be available. So again, possible stages, talk to a patent attorney. Please do that. DIY is possible, but its legal help is useful but fairly expensive. Next slide. So what are the rights of the holder? The holder of a patent, once it's granted by the patent office, and by the way, unlike copyright, which is which doesn't need to be registered to exist, or trademark, which registration is very useful, but there are some rights in just from use. In patent, there's no rights other than it gets granted by the government. It's one of those things where the government's signing off on it is a necessity to get patent right. But if it's signed off on, the holder gets a 20-year monopoly. And that monopoly covers the things that the patent was granted on. The patent might be granted on portions of the request rather than the whole request, might be on whatever, but whatever it is that has been granted as the protected piece of the invention. The holder gets 20-year monopoly in the U.S., but that's only the U.S. It's only in places where the patent is obtained. And here we get to a whole interesting strategy of, do we file internationally? Don't we file internationally? The cost just went up astronomically if we do, but on the other hand, if we don't file internationally, can folks in Brazil just use it? And the answer might be yeah. But if I didn't file in Brazil, so again, there's a bunch of international considerations to keep in mind. If it's a major product, maybe it's worthwhile getting some folks in to help finance it, whatever. But anyway, that's a matter for corporate law and finance, but it can be worthwhile. What happens if the holder gets it? Our old friends, the injunction, stop. Damages, hey, this is the money that you cost me, or the money that I should have gotten from you. And then an at the border exclusion is also sometimes possible. So those three that we saw previously is what we get here. Offense, when available. When you can get a patent, it solidifies a business line against competition, or it can also allow profitable licensing. If it's something that we're not going to develop ourselves, but we can license to other folks, cool. Then that opens that up as a possibility. And opens it up without competition, in effect, for at least for the 20 years. So we have that way of doing it is ours to exploit. Now, that said, there are other ways around this. I mean, there are folks who will write around a patent and go, ooh, we can do something that's similar, but we'll do it this different way. And if we're doing it different enough, the patent won't cover it. Okay, well, there we go. Another thing that's, by the way, that I should mention is that part of the deal on the patent is the patent gets published when granted. And so people now know how to do it. Yeah, maybe that they can't do it for 20 years, but you've told them how to do it. So it's out there. On defense, again, avoid infringement. Check the existing patent landscape. And by the way, that can be useful for ideas as well. Oh, they're not doing it as well as I could do that. Maybe I'll get that. But defense is also interesting. Sometimes if there's a challenge, sometimes we can invalidate the patent. If it wasn't properly granted, we get a second chance. If someone is suing us for patent infringement, we can go, ha, 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 guess what? Your patent wasn't any good. And that actually succeeds a moderate amount of the time, and is a danger, in fact, of using it for offense, using it to try and shut other people down, and then come in and say, hey, patent wasn't properly invented. So patent is for that list of 4 items of manufacturers, machines, compositions of matter, and methods. It has to be novel, useful, non-obvious. It has to be then registered. If it meets those criteria, perhaps we can get it registered. Once registered, you get these rights of the holder going forward. And by the way, it is only a 20-year monopoly. The copyright is for a long, long time. The patent is not for a long, long. It's not the same on the same scale as patent. Are there questions about patent? Okay. Next slide. Trade secret. This is the last one on my list. And here's some resources. This actually doesn't have a government office the way the others do, and so my reference here to you is the National Law Review has an article on trade secrets, what you need to know, that I think is still publicly available to folks. What does it cover? What does it cover? It's covered purposes. It covers profitable secrets. It doesn't protect the information itself. So if people reverse engineer it in a permissible way, cool. Patent says you can't do it no matter how you do. By the way, we'll tell you, but you can't use it. Trade secret is the reverse. It says, hey, we're not going to tell you. We're going to protect people's secrets from being spied or stolen. But what we're not going to do is protect the information itself. It's an interesting difference here. So the elements of the protection is that it must A, be a valuable secret. B, the owner must take reasonable precautions to protect it. So in other words, I have to actually be trying to keep it secret. If I'm trying to keep it secret and somebody figures out a way to steal it, I can get some protection against that theft. If I'm just letting it sit around on my work table or throw it out in the trash can and anybody can see it, it's not a trade secret because I didn't keep it secret. And I didn't take reasonable precautions to protect it. So the owner can sue if an outside party uses improper means to get it. And those improper means are typically either some kind of industrial espionage, spying of some kind, or corrupting somebody with a duty not to disclose. A classic example of this was a couple decades ago. One of the secretaries in the home office of the Coca-Cola company apparently got in touch with the Pepsi company and said, I've got the formula. I've got the secret formula, which came across my desk. And would you like it, Pepsi, if you'd like to pay me? Well, Pepsi ratted her out. Pepsi told her no, go, and then reported it to the Coca-Cola company, partly because they were afraid that maybe the Coca-Cola company was doing this as a ruse to incriminate them, but also partly just being good citizens. And that person had a lot of trouble because Coca-Cola company takes care to keep this secret, and the individual as an employee had a duty not to disclose the secrets of their employer, and so this was an improper means, basically. More recently, just a couple years ago, one of the folks working on, I think it was the Google car, went off to Tesla or vice versa, and took a bunch of the details with him. Got convicted. I was going to go to jail actually for trade secret, and Trump pardoned him at, I think it was at Musk's request, but I'm not sure about that. Anyway, so again, these things can be taken seriously. Elements of the protection, there we go. So improper means include theft, bribery, misrepresentation, breach or inducement of breach of a duty to maintain secrecy, or espionage through electronic or other means. So basically, no spying, no lying is the piece here. Trade secret 2. If I can have next slide. Precautions. What are taking reasonable precautions? Physical security. Lock stuff up. Cyber security. Don't leave the laptop open on the desk. Don't have password protection. The things that would be reasonable security. Have NDA, non-disclosure and agreements, and confidentiality agreements with those with access. That's why I was suggesting in the makerspace kind of thing. Are there NDAs? Sign, hey, confidentiality. Hey, you're not going to blab this. This is a private showing. It's not a public showing. It's a private showing for you, and you're not going to blab. That can help establish that network of precaution, physical security, and legal security, as it were. What are the rights? There's no time limit. This is cool. If it's patented, it goes away in 20 years. If it's copyright, it goes away eventually. If it's a trade secret, it's just, it's sitting there. As long as it can be kept secret and is useful, a useful secret, and there's reasonable precautions, it can sit there a long time. See the Coca-Cola company. But again, it's no defense against reverse engineering or independent discovery. The item itself is not protected. What's protected is the ability to keep it secret. Offense use cases, not just technology. It can also be customer lists. Customer lists are a big deal on this. Employees running off with a customer list typically are running off with a trade secret. That can be attacked. Other valuable private information of the business. Take precautions. Again, that's the key element here. It needs to have a reasonable precautions. So take them. Defense and use cases. Behave yourself and be careful with new hires. Don't try and steal other people's trade secrets yourself, and be careful with new hires, because if new hires come across, they can sometimes carry the trade secret stuff that could make the new employer liable if they do that. By the way, new hires are allowed. It's not a trade secret. Their general knowledge of a field and abilities to earn a living in a field is not a trade secret. But the specifics of things like customer lists or the design of a particular item, those could be trade secrets in that context. Okay, questions on trade secret? Okay, well, that's my big four. The big four again are copyright, works of authorship, trademark, designations of origin, patent, basically inventions, and then trade secrets, which are useful things, useful bits of information or ways of doing stuff that are secret, that are kept secret, and where there's specific and sufficient precautions to cover. Next slide. Chris, you became visible for a moment. You have a question.
Sorry, I think I actually understand more. That other question I had loops back to copyright. So
yeah, go ahead.
Come back to me at the end.
I think we are at the end.
Yeah.
Actually,
Oh, okay.
I'm going to talk about our availabilities and stuff. This is the slide that tells you how to get in touch with us. But before we get there, let me take questions. So, Chris, what's your question?
Okay, super. So I'm working with a company that has a private data set, sort of a bunch of writing
Right.
that they're considering selling to an AI firm for the development of a model, assistant model in a particular industry.
Right.
So I'm imagining that that's most heavily in copyright basket.
There might be a little bit of copyright in the data, but essentially data lists are not seen as works of authorship. They're just seen as facts. Copyright doesn't cover factual content. So there was a big lawsuit about 50 years ago or more now about the yellow pages, and the phone company tried to say the yellow pages are copyrighted because of all our work on them. And basically they came back and said, no, there's no creativity. It's just a data list. So data sets are hard to cover by copyright. What data sets are typically more covered by is some version of trade secret, where they're kept confidential. Their use is extremely limited, that kind of thing. So in a contract to license data to another company, that is often heavily negotiated with clauses about what it can be used, when it will be destroyed. No rights transferred, only transferred for this very limited purpose, will be kept secret. Remember, the trade secret, you got to have the reasonable efforts, and so that's put in the contract. AI is interesting because one of the things that we run into in the AI context is that if the AI it's being used to train is a general AI like ChatGPT, now guess what? The whole GPT has that data. Some of the AIs have the ability to have silos within their AI of data silos. That's really important to look to, because otherwise that data is just now ingested into the AI, and the AI knows it.
Right. It's fully consumed.
Yeah, exactly. So that's worth paying some attention to, A, and the contracting process, and B, in the actual use of what's being used. Is it siloed in a way that will in fact keep it secret and not just make it one of the general assets of the AI?
Thanks. And so you're saying data sets is more trade secrets and less copyrightable. One aspect of the asset is, a whole lot of emails and a whole lot of articles that were written by
those
could
be
data.
Typically could be copyrightable, because now they're expressions of words, etc.
Yeah.
Although who has that copyright is interesting, because an email is typically the original copyright is in the author of the email. Now, if the author of the email was producing it in the context of employment, it might be considered a work for hire.
Right.
Or there may be agreements from that author up. But again, the company who got all those emails has to know where it got them from.
Right. Yeah, I think it would be covered under work for hire, and I think the parties are in agreement about that. So
okay,
that's
again, an example of where specific lawyering could be very useful, but that would
for
be
sure.
the general principle involved. Great questions.
Appreciate it.
Great questions.
Yeah,
Other folks.
great talk. Thanks so much. And will you mind emailing the slides out afterwards?
I don't mind having those emailed. So can that be something you guys can do to send the slides about?
Yeah, I will be
Great.
sending those out.
Okay, great.
Wonderful. Thank you so much. Appreciate your time today.
Okay, no problem. Other questions? I'd be happy to have other questions. Again, a lot of information here. Happy to have more. Good. Can I expand on the referral? That's what this slide is. Woohoo! All right. Let me talk about this. At Vermont Law School, we have, or I should say Vermont Law and Graduate School, as we now are. We have the Vermont Small Business Law Center, and you see the SBLC at vermontlaw.edu. Or just the sblc.vermontlaw.edu. We are a center that gives educational background to folks looking to have with questions about how do I set up a business, how do I run a business, all those things. We don't represent at the Vermont Small Business Law Center. Some law school clinics actually take clients on. We provide education, and that means we can't answer specific questions about specific agreements, problems, etc. We can give this exactly as we've done today, kind of an overview, educational piece. What we can do in many cases is to provide a referral of specific questions of the company, of the nonprofit, of the enterprise that's getting going. Say, hey, we can refer you through the Vermont Bar Association to up to 10 hours of free legal services. This is administered by the Bar Association. They have a list of folks who are willing to do it. Basically, we give not typical an amount that's not the typical full price of a lawyer. I think it's something like $70 or $75 an hour. Okay, but a lawyer has to accept that as okay. I'll give up to 10 hours in that context. Most of them are doing it because they're hoping that the business will thrive and that they'll like the lawyer and they'll be for future business. It's a loss leader kind of thing that they're doing. But it's a very nice way to do that. The Bar Association takes a little while to make that assignment. It is again through them that happens, and not through us. But if you're interested in either a further educational consult, or which is actually you probably want to schedule because that's kind of a prerequisite for our referral. Is you gotta put up with us telling you some education for a little bit, and then you can get the referral. So hopefully the education will be useful, and then the referral will be useful as well. Again, the website and the email addresses are there. Send inquiries to that. I'm part of the staff on that. I'm not one of its directors, so I can let you know about it, but somebody else will be dealing with you probably if you go forward. Oh, by the way, there's expedited services for the flood impacted as well. Does that answer the question on how to be in touch with us? Okay. All right. Yes, great. Okay. Let me ask, are there any other questions? Because if not, I think we're getting towards the end here. Anything in the chat? No, that was what was in the chat. Okay. All right. Well, then we're ending a bit early. I don't mean to bail out on you, but I also want to don't keep people going. Anything we should additionally talk about? I guess, is there another slide beyond this one? Nope, that's it. Okay.
Well, I just want to thank. Yeah, I like Chris. I just want to thank you so much for sharing your time and expertise on this subject. I know it's a lot to take in, and it's a really great starting point. And I'd also like to just put a plug in for the Vermont Small Business Law Clinic as well. I've referred a number of the folks that I work with there, and it's really been an incredibly helpful service. It's been something that's been missing in the business community, and so it's a great addition to it to be able to have these to the clients, the free business legal help. So Sophia, if you don't mind, when you're sending out information about today's class, which I know will include the presentation and any links, information about our program, if you could also include the link to the Vermont Small Business Law Center, so folks can easily access that page, and you'll find on that page like a registration page, and you can fill it out to begin the process of accessing their services. So like Oliver said, typically what I've noticed with the folks that I work with, that you'll be offered the free educational session before being assigned to a lawyer. And I encourage everybody that I work with to take that, because it's really an opportunity to learn more so you can maximize your time with the lawyer when you are assigned to one. So
yeah, exactly. So our goal would be, for instance, like our session here today. Hopefully now you've learned enough so that when you go into, say, a lawyer, say, do I have an intellectual property, and then they explain all the different pieces. We've done that, and so you don't have to pay a lawyer for that with that bit. And hopefully now you can go in and say, I think I've got a copyright question, and here's what it looks like to me, and that will save everybody some time.
yeah, that's great. That's great. So thank you once again, Oliver. Sophia.
Very welcome. Thank you for engaging us in your services. Again, mutual admiration. You guys do great work with the folks you help, and thank you for pulling us in on some of that.
Oh, thank you so much. And I need to do, of course, I need to do a quick shout out to Sophia. She is the backbone to what we're, when we offer these classes. I couldn't do it without her, between all the conducting the class, the technology side, getting the invitations out and the follow-up out. Thank you so much, Sophia. And is there anything else that you want to add before we sign off for the day?
Well, I was just going to say right back at you, Simeon. I really couldn't do it without you. And again, thank you to Professor Goodenough for joining us today and for the lovely presentation. I'll be sending the recording out probably at the end of today, so I'll stop it now.
Take care.